Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley. Thanks for joining. So, as you may know, if you've been listening and following the podcast recently, we're in the middle of doing a multiple series financial podcast. And the idea behind the podcast series is to really take a deeper dive into finances and some of the nuance in divorce. Seems pretty obvious when you think about a divorce and the financial aspects of it, that there's usually either a financial settlement or the court, after a trial, awards a financial distribution. Somebody gets some of the assets, the other gets the other part of the assets. We've got debts, we've got child support, maybe maintenance, some of these issues. They may seem fairly straightforward, but one of the things I really wanted to dive into around the many topics that we're getting into as part of this series is the concept of a financial settlement. And that's really going to be the focus of my talk today. As part of the ongoing series, we've got special guests that have come in that talked from the perspective of wealth advising, financial planners. How does someone coming out of a divorce deal with the money that they've received? If they've never paid bills, if they've never invested money, how do they manage that? Estate planning issues. Someone comes out again and now you're divorced and you have assets and income. How do you manage that? If you want that to go to your heirs, how do you manage that as well? Brought in in addition to wealth advisors, estate planning lawyers, business valuators. I've got a business valuation expert who was talking about in a case where there's a business owner. What do you do? What do you look for in valuing a business? Brought in an expert having a conversation around the issue of forensic accounting. What happens, in dissipation claims, lifestyle claims, some of these things where someone has to take a deeper dive in the experts, what happens in a divorce, to again give that sort of behind the scenes look as to what really happens when you have those issues. Well, as far as a financial settlement goes, all of those components in some form or another may come into play, even with respect to budgeting and understanding if you're about to get a divorce and contemplating a settlement, and you're going to get X number of dollars for child support and maintenance, and Y dollars as far as assets go. What does that mean? How do you manage that? Those are things that come in with the assistance of a financial planner. What the value of a business is and how the structure of the buyout of that business is going to come into play is something that also takes into consideration the global picture of what we do in a financial settlement. But before I really get to some of the main thoughts I want to convey, I think we have to step back, and this may seem very elementary, but I would imagine that the range of viewers and listeners is from somebody who's got very little information about a divorce, and somebody else on the other side that may have done a lot of research, maybe even some people who've gone through a divorce or are going through it now, maybe have quite a bit of information. So perhaps I'm speaking a little bit more to the individual watching now and listening now that doesn't fully understand divorce from the very inception. So I'm going to come from a perspective of divorce in Illinois because that's where I am in Chicago. And the laws of the state of Illinois are somewhat interesting, just even with respect to property division. And I'm going to start there because, what you typically hear and what people often think of is that when you're about to settle a case, you split the assets, you split the debts, and everybody gets half. Well, Illinois is not a 50-50 state, although many cases, many divorces, even though settled or tried, end up with a 50-50 division of the assets, but it's not always the case. In Illinois, it's what's called an equitable distribution state. And what that means is that if equity dictates that one party or the other actually receives a larger percentage of the assets, that could actually take place in the context of a financial settlement or even after trial. I think the largest distribution or disparity in the distribution I've had trying a case was about a 75% of the marital estate was awarded to my client after a trial. But in that case, there was a significant non-marital asset, which was a family business that was non-marital. So the husband owned a non-marital business that my client wasn't entitled to. And so equity dictated that my client receive a larger portion of the marital estate. When you get into the context of settlement, sometimes what we try to do in terms of dividing assets is take into consideration one's ability to acquire future assets after the divorce is over. Sometimes you have a situation where there's an individual in the marriage that the trajectory is on the upward, and that his or her career is such that he or she's only going to make more money, acquire more assets, maybe be at an age where he or she is going to work another 20 years. And so the likelihood that that individual is going to accumulate more wealth, accumulate more assets is probable. Whereas you might have in that situation the other individual who may have been home with the kids, who may have a much more inferior income generation, just maybe a basic job, and maybe they were making, call it $40,000 a year, and it wasn't going to be probable that that individual after the divorce is going to accumulate much more wealth or much more assets. And in that context, in a settlement, we might want to negotiate for a disproportionately larger percentage of the assets for the individual who's less likely to be able to accumulate more wealth after the marriage, because that would be equitable. Now, that's just in dividing the assets and liabilities. And again, same with liabilities. You have debts, credit card debts, other liabilities. Those can be distributed in such a way that one party pays more than the other. I'll diverge a little bit and I'll talk about attorney's fees. And I've done talks on attorney's fees, but again, that's part of a financial settlement. And backing up on that, again, the typical rule with respect to attorney's fees is the attorney's fees that are being paid in a divorce case, regardless of whether they're the husband's fees, the wife's fees, they're all going to be paid out of marital assets. So if someone's telling you your spouse is going to pay all of your attorney's fees, don't worry about it, you don't have to pay anything, it's just not true. And don't be misled by that, because an important reason we settle cases oftentimes is because the cost of actually trying the case, in most cases, cost prohibitive. So don't be misled and misguided by this notion that you're going to be able to have this long contested divorce and it's not going to have any impact on you, because that's wrong. What ends up happening is those fees get paid out of the estate, even if one person controls the checkbook. And if that happens, and tens of thousands, sometimes hundreds of thousands of dollars, and sometimes even more in attorney's fees are paid, all that's doing is reducing the overall marital estate. And so when that marital estate is divided, even if you're getting a larger percentage, you're still getting a larger percentage of a smaller pot that is being divided. So always keep that in mind, because that oftentimes gets lost on people, not understanding the actual economic impact of paying attorney's fees on both sides. Now, if one side or the other is paid more than the other, there's typically some type of true-up or reconciliation at the end to say, in this case, husband's attorney was paid $100,000 more out of marital assets than wife's attorneys. Well, then wife should be able to get that added amount of attorney's fees to the husband's attorneys paid back on her side of the ledger. So an adjustment can be made so that there's actually an equalization of the money that went out. Now, when you've gotten to the point where you've got the assets and liabilities, including attorney's fees, taken care of, you still have to take into consideration in a settlement child support and maintenance, if those are applicable. Now, I bring those into the conversation about a financial settlement, although in my opinion, they're a bit of a ancillary issue, because the fact of the matter is, in today's law here in Illinois, child support and maintenance are really governed by formulas. Now, if you're in a marriage and it's a high income family and you've got income north of $500,000, the formulas don't exactly fit your situation. They still can be applied, but the court has a lot more discretion in those areas to award maintenance at different numbers, to award child support at different numbers. But in most cases, when the formula applies, there's very little to fight about. So spending money, fighting, trying to get more or have someone pay less when the formulas are going to dictate, oftentimes is something you really have to look and ascertain whether or not that is an appropriate expenditure of your money in the context of legal fees, because that's really where it's going to be spent. So when we get to situations where we have all of the information in front of us as lawyers, that's the discovery process. We've talked about that in other episodes as well, but throughout the process of a divorce, as a divorce lawyer, my job is to gather as much information as possible regarding the finances of the marriage, where the money is, what the value of assets are, how much is available to be distributed, in what form is it, and so on and so forth, what the income is, so we can calculate child support, maintenance, and those type of things. Once we have all of that information, here's the reality of divorce. The amount of variance in terms of where your case will end up is very limited. In other words, if you take a set of facts, and I'll give you a hypothetical. Let's say somebody makes $400,000 a year, and there's a 20-year marriage, and there's a homemaker and a mother with 3 children, and they have $2 million of fixed assets, and the individual who's making $400,000 is a wage earner, meaning it's a W-2 pay structure. It's not a self-employed business owner. The reality of that case at 20 years in Illinois is maintenance is going to be indefinite. We used to refer to it as permanent maintenance, meaning the income spouse is going to pay maintenance until at such time as there's a substantial change in circumstance. The child support is going to be calculated under the formula. And the assets, by and large, on that type of a situation are going to be a 50-50 division. The most you might argue and see in a case is a 60-40. And again, there's always special circumstances and unique circumstances, but I'm speaking in terms of generalities right now. This is what happens on most cases. So you'd ask yourself then, under what circumstance would a case like that proceed to trial? And where I find myself as a divorce lawyer is oftentimes I'm having to fight with my own clients. I'm having to reason with them to say, listen, do the opportunity cost analysis. Look and see how much is it that you're going to spend going to trial, and what do you hope to gain by going to trial? And when you do that analysis, more often than not, what you realize is you're going to spend a lot more money in legal fees than any incremental gain you might get. You know, in this case, think about it this way. If you had a $2 million estate and 50-50 each gets $1 million, right? If you end up taking 10% or $100,000 and moving that to the other side of the equation, seems like a lot of money, and that's certainly something, or in this case, actually be $200,000, not a $2 million estate. And you say, is it worth it for that? And you say, okay, well, how much is it going to cost to try a case? To try a sophisticated financial case, you're going to spend hundreds of thousands of dollars with good lawyers. To try a case that's simply straightforward, maybe a case with a W-2 wage earner, fixed assets, maybe you're only trying a case for a couple days. But the preparation that's required, making sure all the exhibits are prepared, making sure everything gets into evidence, going through all the prep work, the depositions that get taken leading up to trial, the probability is you're going to spend as much as you're fighting over. And so that's a very hard concept to grasp when you have someone that says, but I can win. I think I can get more. And you agree saying, that's probably true. We probably can get you more money if we go to trial. The problem is it's going to cost you and your husband both that amount of money, and therefore it's not worth it. And so if you're on the side where you don't want to pay the extra money, that's great if the other side concedes. If you're on the side where you say, boy, if you get that extra money, you have an incentive to go to trial, but the economics of it are such that it's not going to pay off in the end. And that's a real tough position to be in. And that's why oftentimes, as a fundamental belief, I think that for individuals in divorce, for their children, for their extended families and friends, getting through the process and moving on with their lives, there's value in that. And that's an intangible value. I can't put a price tag on that. I can only relate that to the viewers and listeners in the context of my experience. I've seen people that while they're mired in the process of a divorce, they they can't heal, they can't get past the issues that caused the divorce. They continue to spend the money paying attorney's fees and experts and court costs and court reporters and all of the extra expenditures that go into getting a contested divorce. And so on the flip side of that, I've had clients where they've been able to get through the process, they've moved on with their lives, and they've gone back to work, and they've been able to invest their money, and they've been able to disconnect from the emotional struggles or the abuse or whatever may have taken place during the marriage, and they begin to live again. So there really is a significant value in moving forward in your life, but there's also an economic value in not spending money to try to get the extra money, where at the end of the day, it's not going to get you anything more. And I say that, and that is clearly against my pecuniary interest as a lawyer, right? I get paid by the hour. Every lawyer in the state of Illinois who does divorce gets paid by the hour. The more the case goes on, the more hours of work go into that, the more your bill is going to be. And so there's a time and a place for that. There's a need. Like I said before, you have to make an informed decision. You have to know where, what we're settling upon is by and large the entirety of the estate in terms of the assets and the liabilities and the income. I'll diverge a little bit and kind of anecdotally explain. I had a situation recently where I had a client whose husband made, call it, $250,000 a year, but it was all W-2 wages. And they had children, they had a house, they had expenses. And so we were able to look and sort of on a general level and say, based upon what he's earning, we could look at tax returns and understand what the taxes that he would pay on that income would result in terms of his net income. We could look at the expenses that they paid on a monthly basis from their financial disclosures and readily understand that there really isn't much money left over after Uncle Sam gets his percentage, the state gets its percentage, and then everybody else, mortgage company, car notes, children's expenses, and so on and so forth. But notwithstanding that, our client insisted that we do a full-blown tracing of money in and money out to see where the income went, because of this belief that maybe money had been hidden. And where we explained to the client, it doesn't make logical sense that he would be able to stockpile money or hide it away somewhere based on the expenses of their marriage as represented by both of them, and based upon his clearly stated and delineated W-2 income. Notwithstanding that, our client asked us to do this, insisted on do that, and they indicated she wouldn't settle before we were able to do that in the process. So we did that. And unfortunately, what we found was exactly what we knew, and which is why we sort of cautioned against going down that exercise. And as is often the case, the amount of money that was found isn't even equivalent to the amount of money that was spent in that labor-intensive process. We have those abilities. We have tremendous paralegals and associate attorneys who are able to do that kind of work if it gets too complicated. As I mentioned before, we've worked with forensic accountants if we really have to get into something more in the context of where you would have a business owner, something outside of a W-2 wage earner. And so again, unfortunately, sometimes there's mistrust in a divorce. That's obvious. But you can't allow the mistrust in your marriage to infiltrate your thinking in terms of how you approach the possibility of settlement. Because once you allow your actions to be driven by emotions, you're going to end up spending money that you wouldn't otherwise need to spend. I mean, if you think about it logically, anyone out there listening, anyone out there watching, if you had $1 million to divide up, wouldn't you rather say, give me $500,000 and you get $500,000 and have $500,000, as opposed to having $1 million, the attorney's getting $200,000, and then fighting over $800,000 instead of $1 million? It's logical. It makes sense. And again, you hire lawyers because you need to know what your rights are. You need to understand what a probable outcome would be. and you need to understand what is actually there. And that's very important because not everybody has financial acumen or an understanding even what's going on in their own household in terms of assets. And that's not uncommon, by the way, and that's something we'll speak to on some other episodes with a financial expert who works oftentimes, and it's not just with women, it can be, sometimes men or women, but in those contexts where you have an individual who maybe doesn't have the level of sophistication, they need to be informed when they make that decision. So I would caution all of you to make sure that you, with your lawyer, understand, as I mentioned before, there are formulas. Understand what the formula would calculate early on. Any good lawyer can calculate what your maintenance and support obligation should be based on preliminary income numbers. So you have some sense of that. That then might allow you to start focusing on budget. If you're going to have X number of dollars in child support and maintenance, then can you continue to own the home? Is that something that makes sense? That's an issue we encounter frequently. People are very much attached to the home. They've raised children there. There's memories there. They don't want to have to leave that home or sell that home. And sometimes economically that has to happen. We tell our clients oftentimes you don't want to be cash poor or house poor, meaning all the money that you're getting in a settlement or in your child support maintenance is going to maintain this beautiful home, and you don't have any discretionary income, you don't have any ability to save. It may not be worth it. So those are tough conversations to have sometimes as well. But once you've worked with your lawyer, you understand what your assets are, what the income is, you can have them on the formula numbers. Early on, you should have discussions and challenge your lawyer. If you are just meeting with a lawyer and they're saying, we can do all of these wonderful things for you, have them explain where they think the case will end up and how they think you can get there. More importantly, if you're fighting for something that's outside of the norm, how much is it going to cost you to actually get that extra amount, and is it worth it? And I would submit to you oftentimes it's not. Settling a case is more often than not going to be in your family's best interest. It's not easy, to get to that point where everyone's on board emotionally and with the proper information. But when there's an opportunity to settle a case, I think you should do that. Because again, when you start talking about your finances in a divorce, we've got a lot of different episodes, we talk a lot of different nuances, but at the end of the day, it's how much money are you going to walk away with at the end of the divorce? Divorce is painful. Divorce is emotional. Divorce is so much more than economics. But the reality is, when you are in court, oftentimes those other issues that are very real are not addressed by the court. You're not going to walk away with a feeling that you've been vindicated if you've been wronged in the marriage, or if you've been abused in the marriage. All you're going to end up with is a divorce decree that says you're legally divorced, and there's going to set forth parameters in terms of what income you get, what liabilities you get, and that's going to be the end of it. Your child support and maintenance will be a component of that. So it's a financial deal. And that may seem cold, it may seem devoid of sort of empathy, and again, it's not. It's sort of the reality of what divorce law is, and that's a really bitter pill for some people to swallow. So I hope you consider that. When we have people we work with here at Beermann, we very much try to manage, those very real emotional injuries and traumas that occur during the marriage, infidelities, abuse. Some of those things are very, very real, but those are not going to be compensated economically. And so if they're not going to be compensated economically, we always try to bring in the help of professionals, mental health professionals, counselors, people to help people with those very real issues so that we can focus on the dollars and cents. Because at the end of the day, like I said, your marital settlement agreement is going to contain all those terms and provisions that set forth what you're going to get financially. And regardless of the amount of money, and this I found to be true in many cases, I've seen many people receive a lot of money in a settlement, but that doesn't make them feel whole. And so those are issues that, again, outside of the court's purview, you'll have to continue to work on But once your divorce is over, I really believe that there's a freedom that comes with that, and you can begin to rebuild your self-esteem. You can rebuild your strength, your own financial independence. All of those things begin to grow once the divorce is finalized. So I hope you listen to all of the financial talks, because again, there's so many nuanced issues within a divorce, some of which relate to business owners as in particular, but just in a regular case as well, in terms of what's marital and non-marital, what's the formulas as far as child support and maintenance, how do attorney's fees really work, how do you budget coming out of a divorce in terms of being able to pay bills, with your child support and maintenance. What does it mean as far as dividing assets goes? These are all part of this series that I wanted to address on a little bit deeper level on an issue by issue basis. But for today, I really wanted to convey sort of the significance of, if you take anything away, it's really weigh the opportunity cost, the cost benefit analysis of spending money to try to get money. Any lawyer who's been practicing family law for any period of time, a matter of a couple of years, in that situation, they will have a pretty good idea as to where a case should end up. If you shoot for the stars and you spend a lot of money, don't be surprised if you don't get there. So be smart with your money, try to get through the process, and make sure that you get appropriate advice and that you work through the process as quickly as possible. As always, if you have questions about your finances in divorce or any other aspect of divorce, you can contact me here at Beermann. Again, my name is James Quigley, your host. I can be reached at 312-621-1225. That's my direct extension. You can call me anytime. Our firm's website is www.beermannlaw.com. That's B as in boy, EERMANNLAW.com. You can look at my profile, get any information you need. Thanks for watching. Thanks for listening. And I hope this was informational for you, and that if anything else, you walk away with a little bit of understanding, a little something behind the scenes, and what divorce is all about. Take care.